I never thought a frozen lake would be the reason I'd end up explaining sovereign boundaries to a federal judge. But here I am, Warren Iverson, standing in my driveway on a bitter January morning in Duluth, Minnesota, staring at a cease and desist letter that made absolutely no sense. The letter, printed on expensive cream-colored cardstock with the Pine Ridge Estates Homeowners Association letterhead, informed me that I was in violation of Article 47, Section 12B of the HOA, bylaws for unauthorized extension of property boundaries onto common area waterfront during winter months. I read it 3 times before I realized they were talking about the ice fishing shanty I'd set up on Lake Superior's frozen edge, about 200 feet from my backyard. My house sat on the northern edge of Pine Ridge Estates, a development of 47 homes built in 2019 along a pristine stretch of Lake Superior shoreline. I'd bought the property in 2023 specifically because the deed included riparian rights extending to the ordinary high water mark. During summer, my property line ended where the beach began. During winter, when the lake froze solid for a quarter mile offshore, I'd always assumed those same property rights extended over the ice. Apparently, Patricia Donnelly, the HOA president, disagreed. I crumpled the letter and walked down to the lake. The January sun hung low and pale over the frozen expanse. My ice shanty, a modest 8x10 structure painted dark green, sat exactly where I'd placed it 3 weeks earlier, positioned carefully using my deed's legal description and a handheld GPS unit. I'd marked the coordinates, I'd checked the boundaries, everything was legal. My neighbor Frank Morrison was scraping ice off his dock when I walked past. He waved, then noticed my expression. "Got the letter too," he called out. I stopped. "You're kidding." "Nope. Patricia says anyone with structures on the frozen lake is violating HOA rules. She's demanding we remove everything by Monday or face daily fines of $500. "Frank, your dock is on your own property." "She says the ice isn't property. She says it's a seasonal common area that falls under HOA jurisdiction." He shook his head. "I've been living here since the development opened. Never had a problem before." I looked down the shoreline. At least 9 other houses had ice fishing shanties, docks, or equipment on the frozen lake. This wasn't just about me. This was Patricia flexing her authority over something she fundamentally misunderstood. "There's a hearing Monday night," Frank continued. 7 o'clock at the community center. Mandatory attendance for anyone with violations. I called my real estate attorney that afternoon. David Chen had handled my home purchase and knew the property inside and out. And, "Warren, this is absurd," he said after I explained the situation. "Your riparian rights don't evaporate when water freezes. The legal principle is well established. The ice is still part of the water body, and your rights extend accordingly." So what do I do? Go to the hearing, present your case, bring your deed and a copy of Minnesota Riparian Rights Statute. I'll email you the relevant sections. This should be straightforward. Nothing about Patricia Donnelly was ever straightforward. Monday evening arrived cold and clear. I drove to the Pine Ridge Community Center with a folder full of documents, my deed, property survey, Minnesota statutes. Chapter 103G regarding riparian rights, and a printout of case law David had sent me. I felt prepared. The community center meeting room was packed. 37 people had shown up, nearly every homeowner in the development. Patricia sat at the front table with 2 other board members, Kenneth Walsh, the vice president, and Diane Sullivan, the secretary. Patricia was exactly what you'd picture when you heard the name. 52 years old, shoulder-length blonde hair with expensive highlights, wearing a cream-colored pantsuit that matched the HOA letterhead. She had that particular expression of someone who'd spent years cultivating authority in the only realm where anyone would give it to her. "Thank you all for coming," Patricia began, her voice syrupy with false warmth. "We have serious business to discuss tonight. As your HOA board, we have a responsibility to maintain property values and ensure adherence to our community guidelines." She clicked a remote, and a PowerPoint presentation appeared on the screen behind her. The first slide showed a photo of my ice shanty. This structure," she continued, "represents a flagrant violation of our community aesthetic standards, but more importantly, it represents an illegal encroachment onto HOA-managed common areas." I raised my hand. Patricia ignored me. The shoreline and frozen lake surface are common areas as defined in Article 47 of our CC and rupees. During winter months, these areas fall under exclusive HOA management. Any structures placed in these areas require prior board approval, which none of you obtained. Patricia, I didn't raise my hand this time. Can I ask a question? She pursed her lips. Mr. Iverson, please wait until public comment. This is public comment. We're the public, and we're here to comment. A few people chuckled. Patricia's face tightened. Fine. What's your question? I stood, holding my deed. My property deed includes riparian rights to the ordinary high water mark of Lake Superior. Those are private property rights that supersede HOA authority. The ice is frozen water, still part of the lake. My rights don't disappear when the temperature drops. Your rights end where HOA common property begins. The lake isn't HOA property, it's Lake Superior. It's owned by the state of Minnesota in trust for the public. Patricia smiled, and I knew I was in trouble. That smile meant she'd prepared for this. Actually, Mr. Iverson, if you'd read your closing documents more carefully, you'd see that all homeowners granted the HOA an easement over the beach and shoreline area for management purposes. That easement extends to the winter ice zone, which we define as any frozen surface within 300 feet of the ordinary high water mark. I felt my stomach drop. That's not in my deed. It's in the HOA declaration, which you signed when you purchased your property. Page 47, Section 12B, subsection 4. I'd read the HOA declaration when I bought the house, but it had been 93 pages of legal boilerplate. I couldn't remember every detail. I'd like to see that provision, I said. Patricia's smile widened. She nodded to Diane, who passed a stapled document down the row to me. I flipped to page 47. There it was, buried in dense paragraphs of legal language. Homeowners grant to the association a non-exclusive easement for management, maintenance, and regulatory purposes over all shoreline areas, including but not limited to beach, dock areas, and seasonal ice formations extending 300 feet from the ordinary high water mark. This is ridiculous, Frank Morrison said from the back. You're saying we can't use the lake in winter? You can use it, Patricia said smoothly. You just need board approval for any structures. We have standards to maintain. What standards? Another homeowner called out. It's ice. Who cares what's on it? I care, Patricia snapped, losing her composure for a moment. I care about maintaining the property values we've all invested in. I care about preventing this community from looking like a trailer park with shanties scattered across the waterfront. Some of us take pride in where we live. The room erupted. People shouted over each other. Patricia banged a gavel that appeared from nowhere. Order! We will have order! She waited until the room quieted. Now, here's what's going to happen. You all have until Friday, January 14th, to remove any unauthorized structures from the ice zone. After that date, a daily fines of $500 will accrue for each violation. Any questions? My hand went up along with a dozen others. Any reasonable questions? Patricia amended. This is going to court, I said loudly. You're claiming authority over state-owned waters. You're interfering with riparian rights. This won't stand. Patricia's eyes locked onto mine. Do what you need to do, Mr. Iverson. But until a court tells me otherwise, HOA rules are HOA rules. Meeting adjourned. I called David Chen from the parking lot. She can't do this, right? I asked. She absolutely cannot do this, David confirmed. That easement language is unconscionable. It's trying to grant private regulatory authority over public waters. No judge would uphold it. But Warren, litigation takes time. Months, probably. Maybe a year. I don't have months. She's starting fines Friday. That's 4 days away. Then we need an emergency injunction. Let me make some calls. Tuesday morning, David called me back with a plan. He'd contacted a litigation firm that specialized in property rights cases. We'd file for a temporary restraining order in state district court, arguing that the HOA's actions interfered with my statutory riparian rights and constituted an unconstitutional taking of property rights without due process. There's one problem, David said. Your shanty is on ice that's technically in Wisconsin waters. I blinked. What? I checked your GPS coordinates against the state boundary line. Lake Superior is divided between Minnesota and Wisconsin. The boundary runs roughly northeast from Duluth. Your shanty is about 40 feet on Wisconsin's side. How does that change anything? It complicates jurisdiction. If we're arguing about riparian rights under Minnesota law, but the disputed area is in Wisconsin waters, we might need to file in Wisconsin court, or we might have a federal question because it crosses state lines. My head spun. David, I just want to fish. I don't want to litigate state sovereignty. I know. Let me research this. I'll call you back. Wednesday, Patricia sent another letter. This one informed me that the HOA had discovered additional violations, including failure to obtain architectural approval for my shanty's color, which didn't conform to the approved palette of earth tones. The shanty was dark green. Apparently, it needed to be tan, beige, or brown. I drove to the community center and requested copies of all HOA architectural guidelines. The office manager, a tired-looking woman named Ruth, handed me 3 binders. Is this really necessary? She asked quietly. The shanty is fine. Patricia's just on a power trip. Tell me about it. She's been worse since Kenneth Walsh challenged her last election. She's trying to prove she's in charge. Ruth glanced toward Patricia's closed office door. Be careful, she's vindictive. Thursday morning, David called with news. We were filing in federal court. Federal court? Why? Because this isn't just a property dispute anymore. This involves navigable waters of the United States, riparian rights under both Minnesota and Wisconsin law, potential Commerce Clause implications, and constitutional questions about property seizure. I've partnered with a firm in Milwaukee, and we're filing in the Eastern District of Wisconsin Green Bay Division. It's the appropriate venue for disputes involving this section of Lake Superior. When? Today. We're asking for an emergency temporary restraining order. There's a hearing scheduled for Friday morning at 9. That's tomorrow. Yes, the judge reviewed our papers and agreed it's urgent given the fine structure. Warren, you need to be there. Can you drive to Green Bay tonight? I looked at my calendar. I'd taken the week off from my job as a civil engineer, anticipating HOA drama. I'll leave this afternoon. Good. Bring all your documents. This is moving fast. I called Frank Morrison to update him. He'd been coordinating with the other affected homeowners, and they'd pooled money to hire their own attorney. Their lawyer was filing in Minnesota State Court. Warren, we might be splitting our efforts, Frank warned. I know, but my situation is different because of the state boundary line. You guys focus on the Minnesota side. Maybe between both cases, we'll shut this down. Thursday evening, I drove 4 hours through a snowstorm to Green Bay, Wisconsin. I'd never been to federal court before. The whole thing felt surreal. Friday morning, January 14th, I stood in the lobby of the federal courthouse wearing my best suit, clutching a briefcase full of documents. David arrived with 2 attorneys from the Milwaukee firm, Rachel Torres and James Kim. They looked sharp, expensive, and confident. The HOA sent representation, Rachel told me. Patricia hired Bradford and Associates. They're a Chicago firm that specializes in HOA enforcement. They filed an opposition brief at midnight. Did they seriously hire a Chicago firm for this? Patricia's not paying for it. The HOA is. She authorized up to $50,000 in legal fees from the reserve fund. I felt sick. The HOA reserve fund came from everyone's dues, including mine. She was using our collective money to fight me. The courtroom was modern and intimidating. Judge Helen Kowalski presided, a woman in her early 60s with sharp eyes and zero tolerance for nonsense. The HOA's attorneys, 3 of them, sat across from us looking equally intimidating. Judge Kowalski reviewed the papers in silence for several minutes. Then she looked up. Let me make sure I understand this correctly. The HOA is claiming regulatory authority over frozen portions of Lake Superior based on an easement in their declaration documents, and they're threatening $500 daily fines for ice fishing shanties. Is that accurate? The lead HOA attorney, Marcus Bradford, stood. Your Honor, the declaration provides clear authority for the HOA to manage common areas, including seasonal ice formations. This is a simple contract dispute between the association and its members. Mr. Bradford, Lake Superior is navigable waters of the United States. How can a private HOA claim regulatory authority over federal waters? The easement is limited to 300 feet from the shoreline. Your Honor, This is essentially an extension of the riparian management rights the homeowners voluntarily granted. Voluntarily? Judge Kowalski's eyebrow rose. Was this easement negotiable when homeowners purchased their properties? It's part of the recorded declaration. All homeowners had constructive notice. Rachel Torres stood. Your Honor, if I may, the Supreme Court has consistently held that navigable waters are subject to federal authority under the Commerce Clause. The HOA is attempting to impose private regulations on public waters, which is preempted by federal law. Additionally, the easement purports to override state-granted riparian rights, which raises constitutional questions under the Takings Clause. What about the state boundary issue? The judge asked. Mr. Iverson's shanty sits in Wisconsin waters, but his property is in Minnesota. This creates a conflict of laws question that supports federal jurisdiction. Moreover, Lake Superior shipping channels remain active year-round. The Coast Guard maintains authority over the entire lake. The HOA's claim to regulate even frozen portions intrudes on federal maritime jurisdiction. Judge Kowalski looked impressed. Mr. Bradford, response? Bradford looked uncomfortable. Your Honor, we're not regulating navigation. We're regulating aesthetic compliance within a residential community. By imposing rules on frozen Lake Superior, on ice within view of the community. So if I'm ice fishing in Wisconsin waters, but someone in Minnesota can see me, Minnesota HOA rules apply? If the fisherman is a member of the HOA and signed the declaration, yes. The judge sat back. That's one of the more creative jurisdictional theories I've heard. Ms. Torres, what relief is your client seeking? A temporary restraining order preventing the HOA from imposing fines or enforcing removal of the ice shanty pending resolution of the underlying claims. We've also filed a complaint challenging the validity of the easement and seeking declaratory judgment regarding Mr. Iverson's riparian rights. Judge Kowalski reviewed her notes. Here's my ruling. The court finds that plaintiff has demonstrated a likelihood of success on the merits. The HOA's claim to regulatory authority over navigable federal waters is highly questionable, and the easement provision appears to conflict with established riparian rights under both state and federal law. Furthermore, the threat of $500 daily fines constitutes irreparable harm. Therefore, the temporary restraining order is granted. The HOA is enjoined from imposing fines or requiring removal of structures on the frozen lake pending further proceedings. We'll schedule a preliminary injunction hearing for next week. Anything else? I wanted to cheer. David squeezed my shoulder. Bradford stood. Your Honor, we request a stay of that order pending appeal. Denied. The order is effective immediately. We walked out of the courthouse into bright winter sunlight. I couldn't stop smiling. We won? I asked. We won the first round, Rachel corrected. This gets a lot more complicated from here. The HOA will fight back hard. She was right. That afternoon, Patricia called an emergency HOA board meeting. By evening, she'd issued a statement declaring that the federal court had exceeded its jurisdiction and that HOA fines would continue as scheduled. She argued that the TRO only applied to me, not to other homeowners. Frank Morrison called me Friday night. Warren, she's insane. She's telling people the court order doesn't count because it's federal overreach. Half the board wants her removed, but she's threatening anyone who opposes her with personal lawsuits. She can't ignore a federal court order. She just did. Saturday morning, I drove back to Duluth. My ice shanty stood undisturbed on the frozen lake, protected by federal injunction. But when I checked the HOA website, I discovered Patricia had posted my name on a violations list, with accruing daily fines now totaling $3,000 for Friday and Saturday combined. I forwarded the website screenshot to Rachel Torres. Her response came within an hour. Filing contempt motion Monday morning. She's going to regret this. Sunday was quiet. I spent the day ice fishing, more out of principle than desire to catch anything. The temperature hovered around 15 degrees. The ice was 2 feet thick and solid. Out here, the dispute seemed absurd. This was Lake Superior, one of the largest bodies of fresh water on Earth. The idea that Patricia Donnelly thought she controlled it was laughable. But back on shore, the reality was different. 3 more homeowners had received fines. Patricia had sent letters to everyone with structures on the ice, claiming the TRO was under appeal and not applicable to ongoing enforcement actions. Monday morning, Rachel filed a motion for contempt of court. She also filed an emergency motion to expand the TRO to cover all Pine Ridge Estates homeowners, arguing that Patricia's selective enforcement violated equal protection principles. The contempt hearing was scheduled for Wednesday, January 19th, 5 days after the original TRO, 11 days after Patricia had issued her first violation letter. Tuesday, the situation escalated in a way none of us anticipated. Patricia filed a cross-complaint in federal court claiming that my ice shanty violated the Clean Water Act because it was an unpermitted structure on navigable waters, and that I was liable for civil penalties up to $55,000 per day under federal environmental law. "She's weaponizing the EPA against you," David explained over the phone. "It's ridiculous, but it's also brilliant. She's arguing that if federal law preempts HOA authority over the lake, then federal environmental law must apply, and you're in violation. An ice shanty doesn't violate the Clean Water Act." "I know, but she's trying to create leverage. She's hoping you'll back down rather than fight both the HOA and potential EPA enforcement." "What does the EPA say?" "I called the regional office. They have no idea what she's talking about. Ice fishing shanties aren't regulated structures, but she's filed the complaint, and now we have to respond to it." Wednesday arrived, and I drove back to Green Bay for the contempt hearing. This time, Patricia came to court. She sat in the gallery with Marcus Bradford and his team, wearing a navy blue suit and an expression of absolute confidence. When she saw me, she didn't look away. She held my gaze like this was a contest she intended to win. Judge Kowalski entered, and everyone stood. "We're here on plaintiff's motion for contempt," the judge began. "Ms. Torres, proceed." Rachel presented evidence of Patricia's continued fine assessments, the website postings, and the letters sent to other homeowners explicitly stating the TRO was not applicable. "Your Honor, the defendant HOA, through its president Patricia Donnelly, has willfully violated this court's order. The TRO was clear and unambiguous. Instead of compliance, we see defiance." Bradford stood. "Your Honor, there was confusion about the scope of the order. Mrs. Donnelly believed it applied only to Mr. Iverson's specific shanty, not to HOA enforcement authority generally." "Did she believe that before or after she consulted with you?" Judge Kowalski asked dryly. "Your Honor, we advised her that the order was appealable and that she could maintain the HOA's position pending appeal." "Did you advise her she could ignore my order?" "We advised her that the order was preliminary and subject to modification." "That's not what I asked. Did you tell her she could continue assessing fines in direct contradiction to my order?" Bradford hesitated. "We may have suggested the order was ambiguous regarding scope." Judge Kowalski's expression turned icy. "Let me be crystal clear. When this court issues an order, it is to be obeyed, period. Not interpreted creatively, not circumvented, not appealed while simultaneously ignored. Mrs. Donnelly, please stand." Patricia stood, her confidence finally wavering. "Mrs. Donnelly, you are in contempt of this court. I'm imposing a fine of $5,000 payable to the court and an additional $5,000 payable to Mr. Iverson for his legal fees associated with this motion. If you continue to violate my orders, the next sanction will be incarceration. Do you understand?" Patricia's face went white. "Your Honor, I was simply following advice of counsel." "Then you need better counsel. Mr. Bradford, I'm sanctioning your firm as well. $5,000 for providing advice that led directly to contempt of a federal court order. You know better." Bradford looked like he'd swallowed glass. "Yes, Your Honor." "Furthermore," Judge Kowalski continued, "I'm expanding the TRO to cover all Pine Ridge Estates homeowners. The HOA is enjoined from enforcing any restrictions on ice structures pending resolution of this case. All existing fines are rescinded. Mrs. Donnelly, you will post notice of this order on the HOA website by close of business today. Understood?" "Yes, Your Honor." We left the courthouse in silence. Outside, Patricia stood on the steps, her Chicago attorneys clustered around her. She was crying, but they were tears of rage, not remorse. "This isn't over," she called out as I walked past. "You're destroying this community." I stopped and turned. "Patricia, I'm ice fishing. That's all I'm doing. You're the one who made it into World War III. You're setting a precedent that undermines all HOA authority. If you win, every homeowner will think they can ignore our rules. Maybe if your rules weren't insane, people wouldn't want to ignore them." She stepped toward me, and Bradford grabbed her arm. "Mrs. Donnelly, don't engage." But she shook him off. "You think you're so smart getting your fancy lawyers and your federal judge, but you're going to lose. The declaration is a valid contract. You signed it. You're bound by it. We'll see what the judge says about that. I'll appeal all the way to the Supreme Court if I have to." Rachel Torres stepped between us. "Mrs. Donnelly, you've been found in contempt once. I'd advise against making threats." Patricia's eyes blazed, but she went silent. Her attorneys ushered her toward their car. Thursday and Friday were quiet. Patricia posted the required notice on the HOA website. The other homeowners celebrated. Frank Morrison organized a victory party on the ice, and 23 people showed up with their shanties, grills, and ice fishing gear. But I couldn't shake the feeling that this wasn't finished. Monday morning, January 24th, I received notice that the HOA had filed an appeal with the 7th Circuit Court of Appeals in Chicago. They were challenging everything: the TRO, the contempt finding, and the court's exercise of federal jurisdiction. "They're going nuclear," David explained. "Appeals can take months or years, but they're also asking for an emergency stay of the TRO pending appeal. Can they get it? It's unlikely, but Bradford is good. He's arguing that the district court committed clear legal error by asserting jurisdiction over what's essentially a contract dispute." The 7th Circuit scheduled oral arguments for February 3rd, 10 days away. Meanwhile, the Wisconsin Attorney General's office contacted Rachel Torres. They'd been monitoring the case and wanted to file an amicus brief supporting our position. The AG's office argued that the HOA's claim threatened state sovereignty over its portion of Lake Superior. Then the Minnesota Attorney General's office called. They wanted to file a brief too, making the same argument about Minnesota's waters. "This is getting big," Rachel told me. "You've got 2 state AGs weighing in. The Coast Guard sent a letter to the court supporting federal jurisdiction. The EPA officially stated that ice fishing shanties don't violate the Clean Water Act, which torpedoes Patricia's cross-complaint. So we're winning? We're winning the legal arguments. But Warren, this is costing a fortune. Bradford's firm has billed the HOA over $70,000 already. Your legal fees are approaching $40,000. How much longer can you sustain this? I'd been using savings and had taken out a home equity loan. As long as I need to. The other homeowners are helping with costs now. Frank Morrison organized a legal defense fund. They've raised $18,000. That actually choked me up. These were people I barely knew, neighbors I'd waved to in passing. They were funding my fight because it was their fight too. February 3rd arrived. I drove to Chicago for oral arguments before a 3-judge panel of the 7th Circuit. The courthouse was imposing, all marble and history. I felt small and out of place. The courtroom was packed. Someone had tipped off the media, and reporters filled half the gallery. Patricia sat in the front row with her attorneys. The panel consisted of Judge Andrew Morrison, Judge Catherine Liu, and Judge Robert Henderson. They looked stern and intimidating. Bradford argued first, claiming the district court had erred by asserting jurisdiction over a private contract dispute. He argued that riparian rights were state law issues and that federal courts shouldn't interfere with HOA governance. Judge Liu interrupted him. "Counsel, are you arguing that Lake Superior isn't navigable waters of the United States?" "No, Your Honor. We're arguing that the frozen surface during winter months has different legal status than open water." "Based on what legal authority?" "Based on the historical treatment of ice as real property under common law." "Ice as real property?" Judge Liu sounded incredulous. "Lake Superior freezes and thaws annually. Are you suggesting property rights shift with the seasons?" "We're suggesting that the physical nature of ice creates different legal relationships than liquid water." Judge Morrison leaned forward. "Let me posit a hypothetical. If Minnesota passed a law declaring that all ice on Lake Superior belongs to the state, could they enforce that law against Wisconsin residents fishing on Wisconsin's side?" "No, Your Honor. because that would violate state sovereignty. So Wisconsin has sovereignty over its ice, correct? Yes. Then how can a Minnesota HOA regulate Wisconsin ice? Bradford paused. The regulation isn't based on geography, Your Honor. It's based on contractual obligations of HOA members. So if I'm an HOA member in Minnesota, I have to follow Minnesota HOA rules, even when I'm physically in Wisconsin? If those rules relate to property rights, the member voluntarily surrendered in the HOA declaration, yes. Judge Henderson spoke for the first time. You're arguing that contract law overrides state sovereignty? I'm arguing that the federal court erred in applying federal question jurisdiction to what is fundamentally a state contract issue. Rachel Torres argued for our side, focusing on the federal interests, navigable waters, Commerce Clause implications, and the conflict between federal admiralty jurisdiction and HOA regulation. Your Honors, the HOA is attempting to create a private regulatory scheme over public waters. This isn't a simple contract dispute. This involves fundamental questions about who controls the Great Lakes. If this HOA can claim authority over Lake Superior's ice, what's to stop other private entities from making similar claims? The district court correctly recognized the federal interests at stake. Judge Liu asked, what about the homeowners who voluntarily signed the declaration? Don't they bear some responsibility for agreeing to these terms? Your Honor, riparian rights are property rights protected by the Fifth Amendment. You can't contract away constitutional protections. Moreover, the declaration's easement provision is unconscionable. It purports to grant the HOA authority they legally cannot possess, regulatory control over navigable federal waters. The arguments lasted 90 minutes. When they concluded, the panel took the case under advisement. We wouldn't get a ruling for weeks, possibly months. But something changed in the courtroom that day. The media coverage exploded. By evening, the story was on national news. Minnesota HOA claims to control Lake Superior, ran on CNN. Ice fishing dispute reaches federal appeals court appeared in the Washington Post. Patricia Donnelly became a national punchline. Late-night comedians mocked her. Social media erupted with memes about HOAs trying to regulate the Great Lakes. Someone created a satirical petition demanding the HOA enforce fish color compliance. All fish caught must match the approved earth tone palette. The publicity hurt Patricia badly. Other homeowners began calling for her resignation. A recall petition circulated, gathering signatures. By February 10th, 31 of the 47 homeowners had signed demanding a special election to remove her from the board. But Patricia refused to resign. February 15th, the Seventh Circuit issued its ruling. In a unanimous decision, the panel affirmed the district court's TRO and rejected the HOA's appeal. Judge Liu wrote the opinion, and it was scathing. The HOA's position is not merely incorrect, it is absurd. Lake Superior is navigable waters of the United States, subject to federal admiralty jurisdiction and the plenary authority of Congress under the Commerce Clause. The seasonal freezing of portions of the lake does not transform federal waters into HOA-controlled territory. The declaration's purported grant of regulatory authority over the lake is void as contrary to public policy and federal law. Riparian rights attach to the water, whether liquid or frozen, and cannot be extinguished by private contract. The district court correctly exercised jurisdiction and properly enjoined the HOA's attempted enforcement. Affirmed. We won, completely and unequivocally. Rachel called me with the news. Warren, it's over. They can appeal to the Supreme Court, but after this opinion, no court will take the case. You won. I should have felt elated. Instead, I felt exhausted. That evening, the HOA board held an emergency meeting. Kenneth Walsh moved to remove Patricia as president. Diane Sullivan seconded. The vote was 4-1, with only Patricia voting to keep herself in power. She was out, but the story still wasn't finished. February 20th, 5 days after the Seventh Circuit ruling, the Wisconsin Department of Natural Resources contacted me. They'd been reviewing the case files and had discovered something troubling. The original Pine Ridge Estates development had never obtained proper permits for shoreline construction. The developer, Lakeside Homes LLC, had built the community in 2019 and sold off all 47 properties by 2021. But in the rush to develop, they'd skipped several wetland permits and allegedly filled in protected marsh areas without authorization. "Mr. Iverson," the DNR agent explained, "this isn't your fault, but it affects your property. Some of the homes, including yours, were built on improperly filled wetlands. We're investigating whether remediation is required." My stomach sank. What does that mean? It means the development itself might have been illegal. We're reviewing whether properties need to be vacated while we assess environmental damage. This was insane. I'd won the HOA fight only to discover my house might be built on illegal fill. The DNR investigation took 3 weeks. They brought in soil experts, wetland specialists, and hydrologists. The media, still following the story, had a field day. "Ice fishing Victor faces new crisis" ran the headlines. March 15th, the DNR issued its findings. 3 homes in Pine Ridge Estates, including mine, sat on improperly filled wetlands. However, the fill had occurred 7 years ago, and the wetlands had been so degraded prior to development that restoration wasn't feasible. The DNR imposed a fine of $200,000 against Lakeside Homes LLC for the unpermitted work. The problem: Lakeside Homes LLC had dissolved in 2023. The company no longer existed. The DNR tried to pierce the corporate veil and go after the developer personally, but he'd moved to Florida and declared bankruptcy. "So what happens to my house?" I asked the DNR agent. "Nothing. You're protected as a good faith purchaser. You didn't know about the violations. The property is legally yours and you can continue living there. But this affects your property value. Future buyers will need to be informed of the wetland history." Great. My property value had just tanked. But then something unexpected happened. Frank Morrison and several other homeowners approached me with an idea. "Warren, what if we dissolved the HOA entirely?" I blinked. "Can we do that?" According to the attorney we consulted, yes. If 75% of homeowners vote to dissolve, the HOA ceases to exist. The common areas get divided among property owners, and everyone manages their own property independently. What about the pool and community center? We'd form a voluntary recreational association. Pay to play. If you want to use the facilities, you pay annual dues. If you don't, you save the money. It was radical, but after everything we'd been through, it made sense. We called a community meeting for March 22nd. 43 homeowners attended. Frank presented the dissolution proposal. After 2 hours of discussion, we voted. 39 homeowners voted yes, 4 voted no. The HOA was dissolved. Patricia Donnelly didn't attend the meeting. She'd put her house on the market the day after being removed as president. By April 1st, she'd moved to Arizona. The legal dissolution took 6 weeks. By mid-May, Pine Ridge Estates no longer had a homeowners association. The common areas were surveyed and divided. Each property owner received a small additional parcel of beach frontage. The pool and community center became cooperatively owned by 21 homeowners who formed Pine Ridge Recreation LLC, a simple cooperative that charged annual fees only to members who wanted access. I kept my ice shanty on Lake Superior all through March and early April, fishing whenever I had time. The ice finally broke up in late April, and I hauled the shanty back to shore. My total legal fees came to $53,000. The legal defense fund covered $24,000. I paid the rest from savings and the home equity loan. It hurt financially, but I'd won something bigger than money. June 1st, sitting on my dock watching boats on Lake Superior, I reflected on the entire insane experience. From Patricia's first violation letter on January 10th to the federal court TRO on January 14th had been just 4 days. From violation letter to the Seventh Circuit, oral arguments had been 24 days. The entire core legal battle, from HOA hearing to federal appeals court, had unfolded in barely a month. It was the fastest property rights case David Chen had ever seen. Frank Morrison walked over carrying 2 beers. He handed me one and sat down. "Hell of a winter," he said. "Hell of a winter," I agreed. "You know what's funny? Patricia actually believed she was right. She genuinely thought the HOA had authority over the lake. Some people get a little power and lose their minds. At least it's over. I nodded, sipping my beer. The water lapped against the dock. A sailboat glided past, its white sail bright against the blue water. "You think she learned anything?" Frank asked. Patricia? "No, people like that never learn. They just find new places to be terrible." "Probably right." Frank stood. "Barbecue at my place Saturday. You coming?" "Wouldn't miss it." He walked back up the beach and I stayed on the dock, watching the lake. Somewhere out there, 200 feet from shore in what used to be Wisconsin waters during winter, my GPS coordinates marked where my ice shanty had sat. It seemed absurd now, all that legal warfare over a simple fishing shack. But it hadn't been about the shack. It had been about control, about rights, about whether one person could impose arbitrary authority over something as vast and indifferent as Lake Superior. The lake had been here for 10,000 years. It would be here for 10,000 more. Patricia Donnelly, the HOA, the lawsuits, the federal courts, all of it was just noise against the timeless reality of water and ice, freezing and thawing, seasons turning according to rhythms that predated human property rights by eons. But within that noise, something important had happened. Rights had been defended, overreach had been checked. A community had come together and decided that maybe, just maybe, they could govern themselves without someone like Patricia telling them what color their ice fishing shanties should be. I finished my beer and went inside. The DNR issue resolved itself over the summer. A class action lawsuit against Lakeside Homes LLC's insurance carrier resulted in a settlement that provided compensation to affected homeowners for diminished property values. I received $42,000, which covered my legal fees with money left over. By August, life in Pine Ridge Estates had returned to normal. New neighbors moved into Patricia's former house, a young couple with 2 kids who thought the whole HOA story was hilarious. "We specifically looked for a place without an HOA," the husband told me. "When we saw yours had dissolved, we knew it was perfect." September arrived with cool winds and the first hints of autumn color. I prepared my ice shanty for another winter season, repainting it a darker green just because I could. No architectural review board, no approval needed. Just me and my property and my right to use the lake. When January 2027 came, I set up my shanty in exactly the same spot as before. The ice was thick and safe, the fish were biting. And this time, there were no violation letters, no HOA hearings, no federal lawsuits. Just ice fishing on Lake Superior, the way it was supposed to be. Frank set up his shanty 50 feet from mine. Kenneth Walsh put up one nearby. By mid-January, 15 shanties dotted the frozen lake off Pine Ridge Estates, a colorful collection of structures in every color imaginable. Some were green, some blue, some red. One was painted with camouflage. Another had flames on the sides. They were beautiful. One Saturday, I saw a news van driving slowly past the community. They stopped and filmed the shanties, and that night the story aired on local news. 1 year later, community that dissolved, HOA over ice fishing. Dispute thrives without restrictions. They interviewed Frank. Best decision we ever made. No more fees, no more rules about what color your mailbox can be. No more Patricia Donnelly telling us how to live. We're happier, our property values are stable, and we actually talk to each other now instead of sending violation notices. The reporter asked about me, but I declined to be interviewed. I'd had enough publicity to last a lifetime. February brought a polar vortex and the ice thickened to 3 feet. People from other communities started coming to fish near Pine Ridge, attracted by the story and the welcoming atmosphere. We didn't chase them away. More shanties appeared, temporary visitors who came for a day or weekend and then disappeared. The lake was for everyone. That had been the point all along. March 10th marked 1 year since the HOA dissolution vote. Frank organized an anniversary party on the ice. 30 people showed up with food, drinks, and ice fishing gear. Someone brought a portable speaker and played music. Kids skated on the cleared ice nearby. Standing there surrounded by neighbors and friends, looking at the frozen expanse of Lake Superior stretching to the horizon, I felt something I hadn't felt in years. Genuine community. Not the forced rule-bound, compliance-monitored community Patricia had tried to impose, but real community based on mutual respect and shared space. We didn't need an HOA to tell us how to be good neighbors. We just needed the freedom to be ourselves and the common sense to treat each other decently. As winter faded and the ice began to break up in April, I hauled my shanty back to shore one last time. The structure had weathered 2 seasons now and showed wear from wind and weather, but it had served its purpose beautifully. That evening, David Chen called me. "Warren, I wanted to update you on something. The Seventh Circuit opinion in your case has been cited in 3 other HOA disputes around the country. You've created precedent that's helping other homeowners fight back against overreaching associations." "Really?" "Really. There's a case in Texas where an HOA tried to regulate what homeowners could do on a river adjoining their properties. The homeowners cited your case, and the court shut down the HOA. Same thing happened in Oregon with a lakefront community. Your fight is helping people you'll never meet." That felt good. Better than winning. Better than the money. Better than everything else. Knowing that standing up to Patricia's absurd power grab had helped others do the same. Thanks for letting me know, David. Thank you for having the courage to fight. A lot of people would have just removed the shanty and paid the fines. I'm too stubborn for that, he laughed. Stubbornness has its virtues. May arrived with warming temperatures and the return of boats to the lake. I spent weekends on my dock, reading and watching the water. The sailboats and fishing boats glided past, and sometimes people waved. I waved back. Life was good. One afternoon in late May, almost exactly 1 year after my reflection on the dissolved HOA, I received a letter. Not from an HOA this time, but from a law school professor in Wisconsin. She was writing a case study about my dispute for her property law class and wanted to interview me. "Your case beautifully illustrates the tension between private ordering through restrictive covenants and inalienable property rights," she wrote. "It's become required reading in my curriculum." I agreed to the interview and drove to Madison in June. The professor, Dr. Eleanor Hartman, was enthusiastic and brilliant. She'd analyzed every aspect of the case and seen dimensions I hadn't even considered. "The fascinating part," she explained, "is how rapidly the case escalated through multiple levels of jurisdiction. You went from an HOA hearing to federal district court to a federal appeals court in less than a month. That's virtually unprecedented for a civil property dispute." It felt unprecedented while living through it, and the final Seventh Circuit opinion is now considered one of the definitive modern cases on the limits of HOA authority over navigable waters. Judge Liu's language about absurdity has been quoted in at least 7 subsequent decisions. We talked for 2 hours. She asked about my motivations, my decision-making process, how I'd handled the stress. I tried to be honest. Yes, I'd been scared. Yes, I'd wondered if I was crazy to fight this hard over an ice shanty. But I'd also known that giving in would mean accepting that someone like Patricia could impose arbitrary authority over fundamental rights. "You were right to fight, Doctor," Hartman said. "Cases like yours define the boundaries of acceptable governance. They remind us that property rights have meaning beyond what's written in private contracts." Driving home from Madison, I thought about that. Property rights, riparian rights, the right to fish on a frozen lake without some self-appointed authority figure telling you what color your shanty should be. These things mattered. Not because they were grand or impressive, but because they were fundamental. The right to be left alone. The right to use your property without unreasonable interference. The right to tell Patricia Donnelly, politely but firmly, to go to hell. Summer passed peacefully. I worked, fished, maintained my house, and enjoyed the absence of HOA drama. The recreational cooperative that managed the pool and community center functioned smoothly with minimal bureaucracy. If something needed fixing, people volunteered to fix it. If money was needed, members contributed. Simple and effective. September brought news that Patricia had become president of her new HOA in Arizona. I heard this from Diane Sullivan, who'd remained friendly after the dissolution. "She's apparently already threatened 3 homeowners with fines," Diane said, shaking her head. "Some people never change. That's Arizona's problem now." "True, but I feel sorry for her neighbors." I did too, a little. but mostly I felt grateful that she was 2,000 miles away. As autumn turned toward winter and the temperatures dropped, I began preparing my ice shanty again. This would be the third season. I'd made improvements: better insulation, a more efficient heater, comfortable seating. The shanty had become a refuge, a place to sit in silence on the frozen lake and watch the world disappear into white. December brought the first solid freeze. By early January, the ice was safe. I hauled my shanty out to the familiar coordinates, set it up, and drilled my fishing holes. Inside the warm shelter, listening to the wind outside and the occasional pop and groan of the ice, I thought about everything that had happened. The legal battle, the dissolution, the transformation of Pine Ridge Estates from an HOA, controlled development, into a genuine community of independent homeowners. It had been worth it, every dollar, every hour, every moment of stress and uncertainty. Because now I sat here in peace, fishing on Lake Superior, exercising rights that had been tested in federal court and affirmed by one of the most respected appellate courts in the nation. My phone buzzed. A text from Frank. "Catching anything?" I replied. "Not yet. Ice is perfect, though. Come over for dinner tonight. Kelly made chili." "I'll be there." I put the phone away and watched my fishing line. The afternoon sun slanted through the shanty window, painting everything gold. Outside, the ice stretched away in every direction, a vast white emptiness that was somehow full of possibility. This was freedom. This was why I'd fought, not for the principle in the abstract, but for this exact moment, sitting in my green ice shanty on Wisconsin waters, warm and content, answerable to no one but myself and the patient fish below. A tug on my line brought me back to the present. I pulled up a beautiful lake trout, maybe 4 pounds, its scales shimmering in the golden light. I held it for a moment, admiring it, then released it back through the hole. Catch and release. Take what you need. Leave the rest. Good advice for fishing. Good advice for life. As darkness fell, I packed up and walked back across the ice toward shore. Lights glowed in the windows of Pine Ridge Estates. Smoke rose from chimneys. The community center was lit up for some event or another. Home. Not because an HOA told me it was home, but because I'd chosen it, defended it, and made it mine. I reached my property and looked back at the lake one last time. My shanty sat solid on the ice, a dark shape against the twilight. Tomorrow I'd be back, and the day after that. All winter long, for as long as the ice held and the fish were biting, and the frozen lake called me out into that beautiful, pristine silence. Patricia Donnelly had tried to take that away from me. She'd failed. The lake remained. My rights remained, and I remained, stubborn and satisfied, ready for whatever came next. But nothing came. Just winter and ice and fishing and peace, exactly as it should be.